Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Aisyah binti Muhammad Nur Arif. My metric number 1212366. In this video, I would like to discuss about the related case regarding to the topic of Islamic law in civil court and the jurisdiction conflict. So, in this presentation, I choose the case of Dalip Kaur against Pegawai Polis Daerah, Balai Polis Daerah Bukit Mertajam and another in 1992, 1 MLJ 1. And I will discuss this case on the grounds of the effects of the Article 121 Clause 1A of the Federal Constitution. First and foremost, the parties that were involved in this case are: first, Dalip Kaur, who is the mother of the deceased, named Gurdev Singh. And the respondent in this case are Pegawai Polis Daerah, Balai Polis Daerah Bukit Mertajam and another. Next, let's move on to the legal issue in this case. The legal issue in this case is whether a deed poll declaring the deceased renouncing the Islamic faith and practicing Sikh faith is enough to consider the deceased to have converted out of Islam. But I would like to discuss another legal issue in this case, which is whether the High Court have the jurisdiction to determine this case on the ground of effect of Article 121 Clause 1A, since the matter dispute in this case falls exclusively under Sharia Court's jurisdiction. Next, let's take a look at the facts of the case. This case was about a mother who would like a declaration about his son named Gurdev Singh has died as a Sikh and allowed her to take the deceased body. Next, Gurdev Singh was raised practicing the Sikh faith. But then, after meeting a girl named Siti Noraini, he fell in love and successfully converted to Islam. But before Gurdev Singh passed away, his mother said that he had made a deed poll renouncing Islam and had practiced Sikh faith, which is enough to prove that Gurdev was no longer a Muslim. Next, let's move on to the court decision. In this case, the courts have followed the fatwa of Kedah, which state that a person is not considered as converting out of Islam by a deed poll if they have not gone to any Sharia court for any application to renounce Islam. Second, since Kedah did not have any provisions concerning to those who would like to renounce Islam, the courts are of the view that clear provisions should be incorporated in all the state enactments to avoid difficulties of interpretation in the civil courts. The last one, the courts have held that under Article 121 Clause 1A of the Federal Constitution, renouncing Islam is under the jurisdiction of the Sharia courts and not the High Court's jurisdiction. Later come the ground of judgment. Since the question to be determined is whether the deceased had renounced Islam during his lifetime, Muhammad Yusuf, which is the Supreme Court Justice, on the view that Sharia courts is the only platform that can be determined the answer to the question about the Muslims' faith. The view of Muhammad Yusuf, which is the Supreme Court Justice, as a result of the effects of Article 121 Clause 1A of the Federal Constitution. Article 121 Clause 1A of the Federal Constitution provides that the courts referred to in Clause 1 shall have no jurisdiction in respect of any matter within the jurisdiction of the Sharia courts. As an information, this is the new clause of Article 121 of the Federal Constitution, which is effective from 10 June 1988. Relates to Article 121 Clause 1A of the Federal Constitution. The Chief Justice, Hashim Yob Ehsani, states that Article 121 Clause 1A has taken away the jurisdiction of the civil court in respect of matters within the jurisdiction of the Sharia courts. Next, Muhammad Yusuf, which is the Supreme Court Justice, state that this is a matter which is within the jurisdiction of the Sharia courts and not the high courts. This is because any convert who wish to leave Islam could have the matter which is certified by the Sharia courts. In conclusion, I would like to conclude that the Sharia courts is the only expert and appropriate to adjudicate any matter regarding to Islamic law and hukum syara. Second, Article 121 Clause 1A is included in the Federal Constitution in intention to avoid conflict in the jurisdiction between Sharia courts and the civil court. That's all from me. Thank you for lending your ears. With that, wabillahi taufiq wa hidayah. Wassalamualaikum warahmatullahi wabarakatuh.